Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Kevin Estevez, an Arizona construction lien law expert. Today's webinar topic is Arizona lien waivers. Use caution when signing. So without further ado, I'd like to introduce the fabulous Kevin Estevez.
Thanks, Jesse. Good morning or good afternoon, depending where you are. Let's go ahead and get started. Welcome to the webinar. If you have any questions, please use the chat box on your screen, and we will ask questions at the end. Please refrain from using company names or other specifics in the questions you may ask, and we'll go ahead and answer them at the end of the presentation. So with that, let's jump right in. The agenda for today, we're going to talk about lien waivers in Arizona generally. We're going to go over the 4 specific forms of lien waivers used in Arizona. And then at the end, we're going to talk about some lien waiver do's and don'ts. Lien waivers in Arizona generally. In Arizona, lien waivers are a creature of statute. ARS 33-1008D identifies with specificity the types and specific forms of lien waivers that may be used in our state. They are first, conditional waiver release on progress payment. Second, the unconditional waiver and release on progress payment. Third, the conditional waiver and release on final payment. And fourth, the unconditional waiver and release on final payment. Lien waivers, as you'll see throughout the course of today's presentation, are documents that are used very frequently in the construction process. Most folks familiar with the industry recognize that the typical process when you're submitting a payment application or an invoice is to provide a conditional waiver for the payment you're seeking, and if you're still in the progress payment phase, then provide an unconditional for the last payment that you received. And on construction projects that span significant periods of time, this means that there's numerous lien waivers flowing back and forth, and there are documents that are circulated and used on a very regular basis in the industry, and sometimes folks can get in the habit of maybe not paying as close attention to lien waivers as they should. And if that is in fact the case, there are certain problems that you can run into. So pursuant to 33-1008D, the waiver and release given by a claimant is unenforceable unless it follows substantially the forms provided in subsections D1 through D4. So you'll see this happen a lot in Arizona. You'll see contractors who maybe are not familiar with the state's laws, or new contractors to the state come in and request that claimants follow or use lien waivers that don't follow the statutory forms. Pursuant to that provision of 33-1008D that I just read, the waivers aren't enforceable unless they follow substantially the form that's provided in the statute. And that doesn't mean that, and the key word here is substantially, which is why I've bold and italicized it on the screen. As I said below here on the slide, this does not mean that statutory forms cannot be modified in any way. And there may be some circumstances that we'll get into in a little bit where you want to modify a statutory form in some respect. Signing a waiver, you want to be careful and make sure that you're signing something that is similar to the statutory forms. And if you're asking folks to sign a waiver, you want to make sure that, it's substantially similar to the statutory forms to avoid the potential that it be unenforceable. So really, there's a couple things I want to address before we jump into the specific forms of the lien waivers, and one of those is the dichotomy between progress and final waivers. As the name implies, progress waivers are used when a lien claimant is required to execute a waiver and release in exchange for, in order to induce the payment of a progress payment. Generally speaking, these releases only release lien rights for a specific period of time. And when you're signing a progress waiver, make sure you're using the right type of progress waiver, conditional or unconditional. That is juxtaposed with final waivers, and those are used when a lien claimant, is required to execute a waiver and release in exchange for or in order to induce final payment. Generally speaking, these release all lien rights on a project, and when you're executing a final waiver, again, make sure that you're using the right type, conditional or unconditional. We'll get into that with the next slide. An unconditional versus conditional versus unconditional waivers. This is another dichotomy that exists in the statutory forms and lien waivers in Arizona. Conditional waivers are used, as the name implies, when a claimant is required to execute a waiver and release in exchange for, in order to induce payment, and the claimant is not in fact paid in exchange for the waiver and release, or a single paid check or joint paid check is given in exchange for the waiver or release. As set forth there, the conditional waivers are generally only effective if the payment identified in the waiver is subsequently made. When you're using a conditional waiver, you got to make sure you're using the right type of conditional waiver, either progress or final, and that harkens back to the last slide. You can then juxtapose conditional waivers with unconditional waivers, and these are used when a claimant is required to execute a waiver and release in exchange for, in order to induce payment, and the claimant asserts in the waiver that it has been paid the payment. So whereas a conditional waiver, you're signing and saying, once I receive the payment, my lien rights will be released. With an unconditional waiver, you are saying, I've been paid this, and therefore my lien rights are released. Generally, unconditional waivers are effective even if the payment identified in the waiver is not made. And as you'll see in the statutory forms, those are there's specific language in those waivers that make that clear. And when you're signing an unconditional waiver, again, be sure you're using the right type, whether it be progress or final, given the circumstances. I'll say right here with respect to conditional waivers, there is a prevailing notion that, and some people call it lien waiver math, that when you have a conditional waiver that says that I'm releasing my lien rights if I receive this payment, and you have that actual payment, you put those two things together and it effectively operates as an unconditional waiver, because the condition that is set forth in the conditional waiver, has been satisfied. The first form of lien waiver that we're going to look at briefly is the conditional waiver and release on progress payment. And I've copied the statutory forms, the statutory form of this waiver that's set forth in 33-1008D, and I've highlighted some of the operative provisions. So again, this is a conditional waiver and release on progress payment, and it says that on the receipt by the undersigned of a check. So that's the first highlighted section. The second highlighted section then says, and when the check has been properly endorsed and has been paid by the bank on which it is drawn, this document becomes effective to release any mechanics lien, any state or federal statutory bond right, any private bond right, any claim for payment, and any rights under a similar ordinance, rule, or statute related to a claim or payment rights for person in the undersigned's position, and then it specifies the job. So first point on this is that, again, this is saying that upon receipt of the check and confirmation that the check has cleared, this document then operates as a waiver to release lien rights. Second point, past the highlighted language, you should note that pursuant to the statutory form and pursuant to the language here, the release is broader than just mechanics liens. As I read, it releases mechanics liens, bond rights, any private bond right, any claim for payment. So it is broader than just a lien release. And then the third part I want to discuss briefly on this form of waiver is it says this release covers a progress payment for all labor, services, equipment, or materials furnished to the job site or to the person with whom the claimant contracted through, and then it provides a spot where you can include a date. And that date is something that you need to pay attention to when you're executing these documents. And there's several pitfalls that we'll talk about later that can come into play with the dates, with people not paying close enough attention to the dates they include on conditional waivers. So that is the form of conditional waiver that is prescribed by Arizona statute on progress payment. And now we're going to jump forward to the unconditional waiver and release on progress payment, which is also expressly set forth in 33-1008D. And so you'll notice the first dichotomy with the or juxtaposition with the conditional waiver. The unconditional waiver that we're looking at here says the undersigned has been paid and has received a progress payment in the sum of, and then it includes a blank. So whereas the conditional says, hey, once the payment is received and once that payment clears, this will be operative. This is saying, no, the payment has been received. And again, as I mentioned earlier, the way it typically works, and most folks in the industry are aware of this, is that when you submit your first payment application, your first invoice, and you're required to submit lien waivers. With that first lien waiver, or that first payment application, you'll submit a conditional saying, hey, I've done work through this period of time, I'm entitled to this amount of money, and once I've received that payment, then I'll be releasing my lien rights through that period of time. And then when you get to the second payment application, provided you get paid on the first one, you're going to submit two forms of lien waivers. Now you're going to submit a conditional waiver for the second payment that you're seeking, but also many times the folks upstream, whether it be an owner or a general contractor or a subcontractor that you're working with, will want an unconditional confirming your receipt of the payment for the first payment application. Again, this says the unconditional waiver and release on progress payment says that you've received payment of the progress payment, and the second highlighted portion here says this release covers a progress payment for all labor, services, equipment, or materials furnished to the job site or to person, and does not cover, and it gives a through date. And again, it's important on progress waivers to be mindful of that through date. We'll talk about that more in a minute. Only and does not cover any retention pending modifications and changes or items furnished after that date. The language I talked about where unconditional waivers will be operative even if you don't receive payment is the notice on the bottom. And again, the statute requires this be there. And it says this document waives rights unconditionally and states that you have been paid for giving up those rights. This document is enforceable against you if you sign it, even if you have not been paid. If you have not been paid, use a conditional release form. That's one of the don'ts that we'll talk about is don't sign an unconditional waiver form, whether it be progress or final, and until you've received that payment, you're sure that payment is good. And the legislature was nice enough to include that language in the statute. So if you're a person signing this, hopefully, and you haven't received payment, hopefully you see that notice and you're given an advisor, a warning there that if you haven't been paid, use a conditional release form. So those were the progress waivers. Now we're going to jump onto the conditional waiver on final payment. Again, as this is a conditional waiver, it makes, in the first highlighted section, it makes the release provided for in the waiver conditional upon the number one, the receipt of the check, and a confirmation that the the check has cleared the bank on which it's drawn. So before this is operative, those two conditions have to be met. Again, right after the first highlighted language, after the first highlighted language here, we see that this release is more than just mechanics lien rights. It's got the same broad release that that is present in the other statutes. And then the second portion of the highlighted language says this release covers the final payment to the underside for all labor, services, equipment, or materials furnished to the job site or to, and then it includes a blank, for the person with whom the undersigned contracted, except for disputed claims in the amount of blank. And it includes a space where a claimant can include disputed dollar amounts. And that's a very important thing. So the distinction between the final waiver and the progress waiver is the final waiver doesn't have that through date, because this is now applicable to the end of the project. Instead, it says you're waiving all rights on the project and you receive final payment, but it does give you that provision to include disputed claims. And if you have disputed claims at the end of the project, you want to take advantage of that. Moving on, and I want to be as brief as possible. This is the fourth and final type of lien waiver prescribed by Arizona statute, and this is the unconditional waiver and release on final payment. So because this is an unconditional release, the release language is not conditioned upon the receipt and clearance of the check. It's, again, as reflected in the first highlighted section on this page, the release is specifically saying that the claimant has been paid. But because this is a final release, the second highlighted section, it includes an exception for disputed claims for extra work in the amount of blank, and it leaves that spot for you to fill in as a claimant. So again, if you get to the end of the project and you're asked for a final waiver and there's a dispute as to claims, you want to take advantage of that blank space and list that. If you don't, you are in a precarious position. And again, because this is a unconditional release, waiver and release, the notice that we saw in the unconditional progress waiver is again present at the bottom of this waiver. So lien waivers, do's and don'ts. First, do exercise caution when executing any lien waiver. There's several steps you got to go through to make sure that you're signing the right type of waiver and that you're not unwittingly waiving lien rights that you may otherwise have. First, be sure to use and sign the right type of and statutory compliant waiver. So if the situation calls for a progress waiver, make sure you're using a progress waiver. If the situation calls for a conditional waiver, make sure you're using a conditional rather than an unconditional waiver. And make sure again that the waivers are statutorily compliant. I mentioned before that there are certain circumstances where you want to deviate from the statute. And as someone who may be asked to sign a waiver, there may be certain circumstances where you want to use the statutory form but modify it. And in that circumstance, those circumstances that can be done. And when you find yourself in one of those situations, the fourth do here is probably what you need to do, and it's seek legal assistance before you sign a waiver if you're all uncertain. The third do is be mindful of the time period covered by progress waivers. And there is a potential pitfall that you see in repeated in certain circumstances, and that's the situation where the claimant submits a payment application for, let's say, payment application number 3, and they include a conditional waiver with payment application number 3, and for whatever reason, payment application 3 gets held up and it doesn't get paid. and there's a dispute maybe as to the work that was being done, or there's a slow pay issue on the project, for whatever reason, payment application 3 isn't paid. Well, then another month rolls by, more work is done. The parties are trying to sort through what's going on with payment application number 3, and the claimant then submits payment application number 4. And with payment application number 4, they submit another conditional waiver that has a through date for the work relative to payment application number 4. And they will submit that, and that once the check for payment application 4 is paid, the language in the waiver effective releases all lien rights prior to that through date, including the lien rights that you would have for and rights for payment application number 3 that hasn't yet been paid. So if you have a situation where a payment application is in dispute and hasn't been paid for whatever reason, and you're submitting another payment application, and with that payment application pursuant to the contract, you're submitting a conditional lien waiver, you want to be very, very careful not to waive your rights for the previous unpaid payment application with the conditional waiver you're providing with a new payment application. So that's a pitfall that you see happen on occasion, and that's something you want to be careful of not doing. Lien waiver don'ts. First, don't sign unconditional lien waivers until you receive payment and that payment has cleared. Unconditional lien waivers, as the language in the statute provides, are unconditional, and they say that the lien rights are waived and the claims for payment are waived even if payment isn't made. So a lot of times you will see folks upstream, they'll say, hey, I'm not going to give you payment until you sign an unconditional waiver. And that is can be a precarious situation as a lower stream party that's in need of payment to be in. But generally speaking, you shouldn't sign a conditional waiver till you've received the payment and that payment has cleared. The second, don't unintentionally waive lien rights in connection with progress waivers, and that talks about the timing issue that I discussed previously, so I won't repeat myself on that. And then the final don't neglect to include disputed amounts in final waivers. If there is a dispute over certain amounts and you get to the end of the project, that blank space in the final waivers, whether it be conditional or unconditional, is there for a reason, and make sure that you are using and taking advantage of that space to protect your rights as best you can. And that is all I have today in connection with Arizona lien waivers. But if anyone has any questions, please let us know. I'll be happy to answer them.
Well, thank you so much, Kevin. That was a really great presentation. I appreciate it. There's some really, really important information that you just went over. We do have a question that has come through, and I think you've already kind of touched on it, but I want to kind of get some more feedback if you don't mind. It
Sure.
says, can your customer require you to sign a final unconditional waiver in order to receive the check?
So that's something that happens in practice all the time, and technically, pursuant to the statute, you shouldn't be signing an unconditional final waiver until you have received the check, number one, and that check is cleared, number two. So I know that's a practice that sometimes folks upstream try to strong arm folks downstream into signing that, but the way the statutory scheme, is set up is that you shouldn't be signing, and folks shouldn't be asking for unconditional waivers to be exchanged in connection with providing a check. It should be that you get the check and the payment clears, and then you sign the unconditional waiver. And where the folks that are asking for this are protected is that lien waiver map that I talked about earlier. If you have provided that conditional final payment waiver before you get the check, and then they give you the check, and that check clears, then you have a conditional and you have payment. You put those together, and that effectively operates as a unconditional. So I know that's a practice that that happens in the real world all the time. Generally speaking, it's unwise to sign unconditional waivers before you receive payment and that payment has cleared.
All right, perfect. Thank you so much. And then these are all the questions that are coming in. They're all things that you've kind of touched on. It says, what if I sign an unconditional release without knowing? Is there any way to still have lien rights if they haven't paid?
It's an uphill battle. In that circumstance, you're probably going to talk to an attorney. But if you recall the language in the forms, says that if you've signed that, you've waived your lien rights, whether you've been paid or not. So there may be certain circumstances where there can be arguments around the enforcement of that, but it's going to be an uphill battle, and that's why you need to be very careful. But in that circumstance, I would reach out to an attorney and talk to them.
Absolutely. All right, and then this one, it says, what if a check bounces or there is a credit chargeback and you have a signed waiver? What's your recourse?
Again, that's it gets back to what we talked about earlier, in that you want to wait and make sure that you receive the check and the check clears before providing an unconditional waiver. If you've provided a conditional waiver and the check bounces or there's a credit chargeback and that payment hasn't come through, then you haven't waived your right, because the condition to the waiver has not happened yet. If you signed an unconditional, then it was probably a circumstance where you jumped the gun and signed that, and you should refrain from signing unconditionals to you're assured that those funds are in your account and they're good funds.
All right, perfect. And then I think this is the last question that's come in so far. It says, if you're assigning a release that is not the standard Arizona form, is it then considered invalid?
So if you go back, 33-1008D says the waiver and release given by any claimant is unenforceable unless it follows substantially the form set forth in the statute. And that becomes then a question of how close does the waiver follows. Does the waiver that is signed, does it substantially follow the forms? Is it within that definition? Is it close enough? Is it outside? And so that is a determination that, again, in that circumstance, I think you want to talk to an attorney about the specific circumstance and review the waiver in the context of that particular situation. And there's also a thought process too, where if you go outside the statutory forms, then you're outside of the statutory scheme, but the waiver then can be enforceable to the extent you receive payment. So if you receive payment and it's outside the statutory scheme, then there's an idea that that it's enforceable to the extent of payment. But those are all more complicated issues that really need to be taken on a case-by-case basis. But that's what the statute says, and then it becomes a issue of substantial compliance or not.
Okay, perfect. Thank you so much for that clarification. I think that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. All right, so these are some of SunRay's resources that we have available for you to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Remember, if you're doing work in a nearby state that you haven't worked in before, each state has their own lien laws, documents, and deadlines. So if you go over to our website, you're able to then see what laws are applicable in that state and what your deadlines are. So make sure you are in the know and able to protect yourself to best of your ability. If you can go to the next slide for me, please. All right, so we have a new service available at SunRay. Check it out. We can help you with some of your collections potentially. So if you're interested, give us a call. We'd love to be able to speak to you more about that. Can you go to the next slide for me, please?
Mm-hmm.
All right, so our next webinars with Kevin are going to be Thursday, September 27th. That's what happens after I record my lien. How do I get paid? And then there's another one that's going to be in December, how to get the bonding company to pay. You can go ahead and register for free at sunraynotice.com/education. We'd love to be able to see you guys there. And then next slide, please. All right, so if you are in the Phoenix area, Kevin is going to be presenting alongside of SunRay for a live seminar on September 12th. That's how to get paid faster with liens, bonds, and contracts. So if you are interested, go ahead and sign up and get yourself registered. It's sunraynotice.com/seminar. We hope to be able to see you guys there. It's a 3-hour event, and it is really going to be incredible. We'll get to some of the basics of everything and kind of go over everything in detail. So that's a wonderful opportunity. If you could, the next slide, please. All right, if you don't mind, take a moment to give us a review on Google. We'd really appreciate it. It takes about a minute of your time, but it helps other contractors like yourselves to hear about us. You can always give us feedback as to what topics you'd like to learn about and hear about, so that way we can kind of take it into consideration and make sure that we're getting you relevant information that will help you in the real world. So if you could give us that feedback, we'd appreciate it. And then the next slide, please. And that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you guys at our next webinar. Thanks again, Kevin, for all of your insight. We do appreciate you. I hope you all have a beautiful and wonderful sunny day.